Right, but before I start though, I should tell you that the views I express are my own, and they're not the views of the IWW. Okay. Right, the law. Well, as Charles Causley pointed out in Timothy Winters, it's as tricky as a 10-foot snake. I can remember when I was an NUT rep being told by a barrister, forget any idea of justice as we were going to go to court. Forget any idea of justice. This is a game that we play, and it depends how things pan out in court. So you're in the lap of the gods with the law, and barristers don't come cheap. So if you are, the law is a problem. But it's as well to know the law, because then you can point out to the employers what their statutory obligations are, and very often that will shift them. Okay then, that's the first cautionary note. Well, the law on health and safety in the workplace can be useful, but real worker power, as we all know, lies in their capacity to act collectively. And I hope we'll hear some practical ideas of how that can be achieved. The law alone won't protect you, and neither will government. And that is the view of mainstream TUC unions as well. I think they're beginning to acknowledge that the law is helpful, yes, in a way, but the main power of unions is through collective action. And addressing a point that was made earlier about TUC unions, they have good activists. You don't have to involve the union bureaucracy. I think if we could get other union members, whichever their union, to get behind the campaign, it could be a success. It's boots on the ground. With collective action, it's numbers. So you're going to need a large group of people in each area in order to achieve anything. Okay, I'll get on with it. Again, context is everything. You need to look at the workplace and the sort of workers who are there. Are they prepared to whistle? Is it in their interest to whistle? And it's all against the background of the biggest recession we've experienced since 2008. So I think the other note of caution is a version of the Hippocratic Oath is do no harm. So make sure you know what you're doing, make sure you know what the workplace is, and make sure you know who works there. And preferably have discreet conversations before you start doing it. Next thing, much is made of section 44. And this is to do with the right to refuse dangerous work where a real and imminent danger to a worker and the wider society is perceived. Now, the NEU have run a very successful campaign highlighting the issue of safety in the workplace, delayed the opening of the schools, and in some people's view, it was what got Rebecca Long Bailey the sack, as being too close to the NEU and being seen as a person obstructing people's ability to return to work. Now, the NEU has got recognition agreements in their workplaces. They can act collectively. Most workers do not have their power, so shouldn't get carried away with whatever power Section 44 gives to workers, or whatever rights and privileges it gives to them. In fact, it gives them very little unless they act collectively. An individual worker, and I don't think any union would give different advice, an individual worker should never use this as a reason to refuse work, only as a collective. You'll get tripped up. The other thing that people turn to with the law is duty of care. An employer does have a duty of care to ensure that the workplace environment is not harmful to both physical and mental health. Again, this is best cited collectively rather than individually. The common law stipulates that an employer must provide a safe place at work, but, and this is a huge but, as a union rep, I have dealt with the HSE, and it's problematic. They'll immediately refer you to the local council. You'll approach the local council and they'll refer you back to the HSE. because of the budget cuts, nobody's got the ability to put people into workplaces to do inspections anyway. So this is very tricky. Without collective power, you really are up against it. Moreover, health and safety inspectors will not visit unsafe workplaces to check on whether or not duty of care has been properly exercised. That's just an example. So how do you prove a workplace is unsafe without some sort of official sanction? And if there's nobody to come out to visit it, you're stuffed. Now, I did send in a sheet. I'm coming on to statutory provisions. And I did send in a list of the various statutes that can be used as tools when fighting the boss. And I hope you've got those links. They've been sent out to people. But the main provisions are the Health and Safety at Work Act 1977. That covers the basics. The 1977 Act, where an employer has to consult union reps about workplace issues. The 1996 Consultation Act, the employer has to consult non-recognised unions about health and safety issues. The Health and Safety at Work Regulations 1999, where health and safety risk assessments have to be carried out. Now this, I think, can be quite powerful. And a review of measures recommended should be documented. So, yeah, I'm coming to risk assessments and this Health and Safety at Work Regulations 1999 a bit later on. And then there's the COSH Act, the Care of Substance Harmful to Health Act 2002. These are the various statutory provisions available to us, and I hope you've got the links. If not, perhaps one of the organisers could remind, I'll send them again to.
We'll send out all the documents to everybody afterwards.
Super,
we'll collect them all together and distribute.
Okay. Thank you, Tim. I did forward them, but if you need me to forward them again, I will do. Now, the statutory provisions apply to all on site, including subcontractors, agency workers, and the self-employed. So everybody in a workplace is covered by it. Now, I think coming to the most useful thing for us and to ask workers where they give their consent and are willing to talk discreetly without risking their employment prospects is a COVID-19 risk assessment. And I think that's the first thing to ask the worker is, has a COVID-19 risk assessment been carried out in your workplace and were you consulted? The other important thing is there a person representing the employer who has responsibility for health and safety? They should have their own health and safety rep. So that's another good question to ask. And if the answer to both is no, it's fairly obvious that nothing's being done to mitigate the risks of COVID-19. A point made earlier by the guy from Birmingham RAG about the bosses sitting at home in comfort while the workers are all out slaving and risking themselves came home to me today. I represented a worker at a disciplinary appeal. The manager was there, I was there, the translator was there, the worker was actually there on site. HR came in over video conferencing.
Yeah.
Which I thought was brilliant and was a real education for the worker. So an employer has to carry out COVID-19 risk assessment. Yeah, this must be documented. Have you seen the documents? Are they documenting stuff? These are all little chinks in their armour that you could find. And should have been done with consultation so that it be challenged. A risk assessment can be challenged. Where possible, occupational health should be consulted about whether or not a risk assessment includes workers with health concerns. To our comrade who was raising disability issues. Yeah, another sort of which mordantly amuses one, is the workers in the shielding group can go back to work in August. So the cull of the disabled continues, not just through the benefit system, but now through going to work. Yeah, I think that's something we do need to challenge. And if it's occurring, yeah, definitely challenge that. Now, the other thing is, make sure that you write everything down. I know this is probably going to bore most of you. It can't be repeated enough, though. Make sure you've documented it, because if the employer hasn't and you have, you've got a strong case. Now, as I'm sure Rob will concur, we don't want to get bogged down in individual casework, but it may be necessary. It might, if we can get a collective grievance sorted. Collective grievances are very good. I've always found them to be very successful. And in fact, I'm trying to persuade a group of workers where I was today that that's their only course of action, really, to achieve anything. You can highlight issues through the grievance, through disciplinaries and things like that, appeals, exhaust, that sort of thing. You can raise issues and alert the bosses to perhaps bad management. But really, a collective grievance is the way to get things done if you're going to go down the casework route. But I would advise against getting bogged down in individual casework. It's just exhausting and doesn't achieve very much and takes years. Evidence. Evidence. All incidents and concerns must be reported to the Health and Safety Executive as a formal notification. So if somebody in the workplace has contracted COVID-19, have the authorities been informed? This is another question to ask friendly workers, workers who are prepared to talk to you. And incidentally, I can recommend the Angry Workers book, Class Power on Zero Powers. There's some very good hints in there about how to engage with workers, the sort of problems you're going to come up against, the various ethnic squabbles. I see we've already started a bit of a sectarian squabble here, but there we go. These things happen. We've got to get through that. Find out, see the lie of the land, see what's going on. And the Angry Workers book is a good introduction to that if you haven't already got experience of it. You'll get some background knowledge from there. Okay, evidence. Has it been? Have the HSE been notified of any incidents in the workplace? And if the employer will not report, then the worker should record responses for the measures that have been taken to address concerns. It's important to establish a paper trail, so you do have things to quote, even if it's just to the press. If a worker contracts COVID-19 and feels that this is work-related, they must have evidence that it is beyond reasonable doubt that the workplace was the source of the infection. Hence the need for documentation before compensation. There's the slogan, documentation before compensation. We can beat Boris with the 3-word slogans if we need to. Make sure it's recorded. If somebody gets COVID-19 in a workplace, if you can get people to start self-organising, they should be recording incidents. And finally, I think I've spoke. I'm a retired teacher. I talk all night. I've got a captive audience until they tell me to shut up. The socio-political economic milieu is problematic. Discussing this today with one of the workers I'm representing, it's very difficult to be militant when there are few jobs around. Of course, the worker's main power is to walk and go to another job if they can't take collective action in their own workplace. That's cut off to them. That might be an advantage. Perhaps people see, well, I'm not going to get a job anywhere else. My only chance of a decent life or survival is to do something about my own workplace. Yeah, there's been social murder due to austerity. I'm chair of Rugby Disability Forum.
Can I ask you to finish up now, if possible?
Yeah, sure. That's it. You shut me up. It's going to be difficult. That's what I was going to say. It's going to be difficult to persuade workers that we're acting in their best interests. Thank you very much.